begin.
Legalized affects your drug-free workplace program, presented by Employment Background Investigations and Orature Technologies. This presentation is approved for 1 credit hour of continuing education from SAPAC for SAPAs. You will receive more information about these credits at the end of the presentation. Welcome, everyone. I'm Jennifer Gladstone. I'm the editor of EBI's Screening News Network, and I'll be serving as your moderator today. EBI is a technology-driven leader in domestic and global pre-employment background checks, drug testing, occupational health screening, and I-9 compliance. In development, implementation, and management of customized screening programs for large and multinational clients. Our services include background screening, drug testing, occupational health screening, and electronic form I-9. We're dedicated to information security. We are the only NAPBS-accredited background screening company in the world to hold both an ISO 7001-2005 certification for information security and an ISO 9001-2008 certification for quality management. Like you, we have been keeping a close eye on Washington and all of the state legislatures with regards to marijuana legalization. As of today, 23 states have legalized pot in some manner, and several more are expected to join that list this year. Early this month, it was presented in Congress to move marijuana from the list of Schedule I drugs to Schedule II. And just 2 weeks ago, President Obama said, I quote, "We may be able to make some progress on the decriminalization side. At a certain point, if enough states end up decriminalizing, then Congress may then reschedule marijuana." End quote. In essence, the president is predicting complete legalization. In the time, as an employer, you still have the right and the responsibility to protect your company, your employees, and your customers by maintaining a drug-free workplace. Now, that said, it's not to be as easy as it used to be. The legal landscape is becoming more jumbled by the day, and the traditional drug screening programs that have become used to may no longer comply with local or even be practical. What do you do? Our very knowledgeable presenter is going to help you with all of that today. I'm now pleased to introduce you to Bill Current. He is the president and founding partner of the Current Consulting Group and is the publisher of the online Ultimate Guide to State Drug Testing Laws at statedrugtestinglaws.com. He is the author of 10 books on substance abuse-related issues, including a popular title, Why Drug Testing. He is also the former executive director of the American Council for Drug Education and vice president of consulting for Employee Information Services. Current Consulting Group is a leading provider of drug testing policy writing issues, working with companies to help them optimize their drug testing ROI. As Bill takes us through his presentation, please feel free to use the chat feature to submit your questions. We'll have a question and answer period at the end of the presentation, and we're going to get in as many of your questions as we possibly can. And with that, I will now hand everything over to Bill.
Well, then, welcome to everybody who has logged into today's presentation. I want to first start out by thanking EBI and Orature Technologies for co-hosting and co-sponsoring today's presentation. This is an incredibly important topic. The time is critical, and there is so much that needs to be said and done when it comes to this issue of legalizing marijuana. We're going to get to all of that today, but again, just acknowledge Orature Technologies. We, here at the Current Consulting Group, we have been conducting a survey of the drug testing industry for the last 17 years. This will be our 17th annual survey, and Orature Technologies has routinely, from year to year, been raised as the top recognized brand in oral fluid testing. So we congratulate them for that distinction again last year. We'll see how this year's survey turns out. Of course, EBI, well known not just in the United States but throughout the world, is one of the top providers of employee screening services, background checks, drug testing, and employee screening services. And so these two companies together bringing today's presentation and this topic to you is a credit to them for their commitment to bringing good, accurate, timely information in the drug testing business, but even importantly to employers who use the services of employee screening providers like EBI and Orature Technologies. This is the overview that we use to promote the webinar. I'm not going to go into detail on this, but we're going to about the fact that not only have states been legalizing marijuana, but we're going to talk about arguments that they're using to successfully make their case, and how those arguments just really are not working. About a book. I get no money for promoting this, but this was a book called Going to Pot, written Bill Bennett and Robert White. I highly recommend it. We have desperate need of high-profile source of sort of counter-argument on the marijuana issue. And finally, there's this book by Mr. Bennett, Mr. White. I've read large parts of it. I kind of get stuck in certain parts, going over and over the statistics that they use, but make the points very well. In fact, let me just read an excerpt right from the very beginning, from the introduction. I won't read much. Let me just share this with you. They say, quote, "We're curious as well as critical moment in our country, just when we're spending more than ever on early childhood education, and many are arguing for even more spending, just are debating the intellectual and motivational needs of our present and future workforce, just as we are concerned about unemployment numbers that are too high, just as we're unveiling a new experiment on universal health care coverage, and just as we're condemning other products deemed unhealthy, like sugars and trans fats, we at the same exact time move back an opinion toward more marijuana legalization. We're spending money and political capital on strengthening the health, education, and productivity of our populace, yet society believes it is appropriate to push for availability of a drug that hinders and negatively affects, perhaps dramatically, those efforts." And they start out the book. I recommend it to you. Again, I'm not getting a commission for any of the sales, but it's finally a very high-profile counter debate to the legalization issue. Hopefully not too late to have an impact. Now, when we talk marijuana, generally speaking, there are trends right now that are very disturbing. And one of them, and this is really very disconcerting, the General Survey, which has been around since the 1970s, for the first time shows that a majority of Americans support the legalization of marijuana. 52% of Americans now say marijuana should be legal versus 42% think it should be illegal. And that's a big jump, according to the survey report. As you can see at the bottom, 25 years ago in 1990, just 16% supported legalization of marijuana. Now we're up to a majority at 52%. That's a very disturbing trend. In the U.S. Senate, thanks to Senators Paul, Gillibrand, and Booker, we now have legislation called Compassionate Access, Research Expansion, and States Act, sometimes referred to as the Career Act, SB 683, that would reclassify marijuana in the Controlled Substances Act from Schedule 1 to Schedule 2. And that's a significant thing. If this bill is passed and signed into law, of course, from what Jennifer read, there's every indication that if such a bill was passed by the Senate and the House and reached the President's desk, he would most likely sign it. This marijuana from Schedule 1 would restrict its availability to Schedule 2, would make it possible for doctors to prescribe. Right now, marijuana as a Schedule 1 drug cannot be prescribed. When you hear people talking about medical marijuana and subscriptions, that's misnomer in this case. Marijuana cannot be prescribed because it is a Schedule 1 drug. It's considered among the most dangerous substances. If we move Schedule 2, as these senators are proposing, it would become a drug prescribed. Now, there's a good chance that could pass in the 104th Congress. Last month, this is from Forbes magazine, March 11, 2015. Last month, there was a bill called the Regulate Marijuana Like Alcohol Act, introduced by about 13 different co-sponsors in the House. Only Republican, incidentally. But that it went too far toward legalizing marijuana. And so this new bill that was introduced in the Senate probably has a better chance. This argument all along that marijuana should be treated like alcohol, that really no difference between the two. All legal, why can't marijuana be legal? Well, if you think about it, marijuana and alcohol are very much alike. Marijuana is the number 2 substance of abuse in America, second only to alcohol. Marijuana is addictive, just like alcohol. Marijuana impairs a person's ability to operate heavy machinery like automobiles, trucks, forklifts, etc., just alcohol. Marijuana causes harm to the human brain. There is scientific proof of this now, just like alcohol does. And marijuana leads to more accidents in the place and on our ways, just like alcohol has proven to do. Yes, marijuana and alcohol are very much alike, despite what the legalization proponents will tell you. They have argued that legal marijuana will not lead to more people using marijuana. Actually, just the opposite has proven to be the case. They've argued legalization would be a benign drug that people would use occasionally on a sort of casual recreational basis. We know that daily use of marijuana is up significantly between 2012 and 2013. Legalization may actually be responsible for the increase in positive drug test results that are in Colorado and Washington, the first 2 states to legalize marijuana generally for quote-unquote recreational use, despite the fact that the legalization people said that would not happen. Legalization resulted in more people dying in marijuana-related incidents such as traffic accidents and overdoses. And that legalization people told us before the laws were passed in Colorado and Washington, and then more recently in Oregon and Alaska. In fact, the results of the legalization of marijuana in Colorado have prompted the governor of that state to publicly regret the bill that legalized marijuana in Colorado. They have been quite opposite of what we were told they would be. Part of this is because the potency of marijuana today is many, many times stronger than it was years and years ago. 30 years, experts say that the potency of marijuana, the THC content, has risen by a factor of 3. There was a study recently that found that the potency values are close to 30%, 30% THC. That's 10% just a few days ago. So in high school back in the 70s and 80s, the marijuana that people in our schools were using was typically a THC content of about 10%, to closer to 30%. It's many times more potent today than it was just 20, 30 years ago. And this rising researchers, because THC content is considered to be responsible for the marijuana-related emergency room visits, psychotic behavior, and damage to the brain. Now, THC is a psychoactive ingredient in marijuana. It's the part of marijuana that changes the mood of the individual who uses it. Okay? Cannabidiol is the content in marijuana that some people claim relieves the physical problems and suffering of certain types of illnesses like schizophrenia, Huntington's disease, Alzheimer's disease, the brain and mood disorders, psychotic episodes. Cannabidiol is the sort of compassionate side of the argument for using marijuana for medicinal purposes. The part that gets people high, makes them feel good, and maybe makes them do crazy things. Well, the THC content is up around 30%. The high people get from smoking marijuana or using marijuana is not going to vary as much from one dealer or one dispensary to the next. Despite, I don't know if you saw the article the other day, Willie Nelson, the famous country singer, is getting ready to come out with his Willie Nelson brand of marijuana, claiming it's better, it's going to give you a better high than other strands or brands of marijuana. Well, according to the research that's out there, all of marijuana is much, much stronger than it used to be. But medicinal effect that supposedly comes from cannabidiol is lower. And so desired relief from suffering and pain that would supposedly come from marijuana is probably not going to be there as people expect. They're going to get, and then they're going to get high in very strong, potent ways, but relief from suffering may not. The experts have argued that it will be there. Say experts loosely. As we get into the sort of the legalization issue, and that's pointed out in a number of sources. So I don't want you to think I'm the only smart guy that figured this out. Do is look at the history of the argument in favor of legalization of marijuana. In the 70s, coming out of the Vietnam War and into the 70s, there were people who wanted to legalize marijuana. They wanted to legalize every other drug as well. They wanted to legalize marijuana. Well, there was no appetite, as we saw from those statistics, to legalize marijuana. The argument switched from legalizing marijuana for recreational use to legalizing marijuana for medicinal purposes, to relieve the pain and suffering of cancer patients, of sufferers of MS, schizophrenia, etc. Well, it took time, but arguments started to catch on. It took about 20 years, but the pro-legalization folks never gave up. But that the end game was never to legalize marijuana simply for medicinal purposes. It would legalize marijuana for recreational use. They simply used the medicinal use or the compassionate argument to get to the point where they could legalize it generally, which they've now done in 4 states, possibly in the District of Columbia. But I need to bring up the point that marijuana in most states is really a farce. There are 10,000 of people in some states that have medical marijuana registration cards. Some are suffering from cancer, MS, or any other truly debilitating illness. In fact, in some places like Arizona, I'll share a statistic on this with you as well. The percentage of people who are actually suffering from some type of serious illness is very low. 3.76% use marijuana to ease the symptoms of cancer. 1.1% suffer from glaucoma, and just over 1% suffer from AIDS. Well, 89.8%, 30,000 people in the state of Arizona as of December 2012, reported by the Arizona Republic, 3,203 people are seeking relief for, quote, severe and chronic pain. And this in one state after another that has legalized marijuana for medicinal purposes. Vast majority, 80, 90, into the 90% range, have a marijuana registered to deal with chronic pain. That's a lot of people that are suffering from chronic pain and from the debilitating illnesses like MS and cancer and AIDS that the legalization folks are telling us. It's really another group of people. A number that would be of concern to all of us, 19,800,000. That number of Americans in a government study admitted to using marijuana at least once in the last 30 days prior to being surveyed. That's about 7.5% of the U.S. population. 19.8 million. Dwarfs, by comparison, all other drug categories: prescription drugs, cocaine, hallucinogens, inhalants, and heroin. Even though cocaine is making a tremendous comeback in some parts of the country, as well as heroin, the people who use marijuana on a regular basis, at least 30 days, is 98 million, just over. That lies, and there is increasing. Is incidence that number is increasing with the fact that the percentage associated with marijuana use by young people is declining. It declined 5% in 2010 to 16% in 2014, according to a study issued by the Facts organization. Meanwhile, the perceived risk of harm associated with synthetic marijuana, like doing spice, increased from 33% to 30%. That's good, and that synthetic marijuana can be very dangerous and harmful. But the perceived of using real marijuana dramatically, and that's because young people are hearing leaders in our community, all the way to the White House, saying marijuana is worse, no more harmful than smoking cigarettes. And so we see dispensaries for marijuana springing up in their communities, and people that adults they perhaps see at school or at the doctor's office or other walks of life cards so they can legally purchase marijuana starts to have an impact on the perceived risk of harm, which should be much higher than this study shows that it is. The place is also at the very same time going up. For marijuana in the workplace increased 6% nationally, according to Quest Diagnostics, one major laboratory, between 2012 and 2013. In Washington, results increased 20%, increased 20% in Colorado and 3% in Washington. The states that have led the way in legalization of marijuana for recreational use. And they have Alaska and Oregon. We can probably predict that drug tests in the workplace in those two states will all increase over the next year or two. The percent of employees who are testing positive for marijuana is up, especially up in the two states that have legalized marijuana for recreational use. And it's an impact, a fatal impact, if you will, in areas. Statistics from 6 states that routinely perform toxicological tests on drugs involved in car wrecks. And these are the 6 states. Okay, the 5 in green are states that legalize marijuana for medicinal purposes. That the statistics include more than 23,500 drivers between 1999 and 2010, so about a 10-year. Shell contributed to about the same percentage of traffic fatalities from the beginning of that 10-year period to the end of the 10-year period. But the percentage of individuals who were under the influence of drugs and who were in fatal accidents increased significantly in 2010 compared to 16% in 1999, with marijuana being the leading drug involved in that increase, contributing to 12% of the 2010 crashes compared to percent in 1999. Or in other words, marijuana-related traffic fatalities increased from 4 to 12%, which it tripled. And I asked the question, is it a coincidence that of the 6 states that we're talking about are instead of legalized marijuana for medicinal purposes? But here's the thing that's very disturbing. Now, I've been in the drug testing industry for a long, long time. I mentioned I worked in Washington, D.C. as part of the U.S. Chamber of Commerce, as part of the American Council for Drug Education. All of the different issues, all of the programs that have been introduced to try to reduce the demand for drugs. And the thing that has the greatest impact, the positive impact, regardless of the walk of life we're talking about, the workplace, treatment, schools, etc., is drug testing. Drug testing is credited by people who used to do drugs, and the main reasons they no longer use drugs. And they're grateful for that because it keeps them honest. And yet, the legalization of marijuana is starting to cloud the issue in such a way that, as you see right in the middle, this, according to the survey that Current Consulting Group does the drug testing industry, 7.6% of drug providers said they are confused and worried about how to deal with marijuana in the workplace, and 17%, the statistic just below that, said that some employers have already eliminated marijuana from their drug panel. So that drug tests, and probably traditionally drug tests for marijuana, that are no longer for marijuana, be confused and worried about the issue. They're confused. They don't know if they have the legal right to address the issue. Worried that if somebody tests positive and they try to terminate employment or suspend employment or, compel the individual to go into some type of treatment program, that it may create a legal backlash for them. And so they're worried, and a growing 17%, 16.9%, have actually eliminated marijuana from the drug test panel. And that's disturbing. We also do a national drug testing survey. We have a question of our survey participants. These are companies that provide drug testing services all over the world. And basically, the vast majority said legalized marijuana is not an issue in the countries where I do business. There's no for it. I don't see it happening. In fact, their biggest concern was that the pro-legalization movement that is so strong and moving so rapidly forward in the U.S. will now have a negative impact on the issue in their country. In other words, the U.S. will actually influence the business to legal marijuana also. So we're leading the in the drug war. We're actually fighting on the other side now, according to those people in countries who are viewing what's going on in the United States. From an international standpoint, there's concern that we're heading in the wrong direction, and it's going to have a negative impact on them. Now we'll go through some of the more recent state laws that have been passed that legalize marijuana. I mentioned Alaska and Oregon. Oregon legalized marijuana for any person 21 or older, not for medicinal purposes only, but for any purpose, for recreational use. That's up to 1 ounce of pot legally. That's about 28 joints that you can have on your person, up to ounces in your home, and up to 4 plants. So let me ask this question, because this is different than the law of Colorado. You can put up to 28 joints on your person at any given time legally in the state of Oregon. Now, I don't smoke. I've never smoked. I would be like to go through 28 cigarettes in one day, but I mean, there are people that smoke 28 cigarettes a day. But what 28 joints? Well, you can sell them, you can share them, or you can smoke them all yourself. In Oregon, it's legal to carry 28 joints on your person at any given time. The law prohibits from firing employees who test positive for marijuana, however. Positive thing in the Oregon marijuana law. But all it says, doesn't any details beyond that. Alaska, when they introduced their recreational marijuana legislation, they basically mirrored the Colorado law. So the state criminal penalties for the possession of 1 ounce of marijuana are eliminated. Permit cultivation of up to 6 marijuana plants, 3 mature, just like Colorado, and permit gifting of 1 ounce of marijuana to another person. So, that's a gift that you can give, on any kind of special occasion to another person. You give them up to 1 ounce or 28 joints of marijuana. But in Alaska, nothing in the law stops employers from prohibiting employees from being under the influence of pot or from drug testing for marijuana. Again, no more, but at least has that much in it. A lot of talk that the District of Columbia also legalized marijuana, just like Colorado, just like Washington, Alaska, and Oregon. That's not exactly true. They did vote to legalize marijuana, they voted to legalize the use of marijuana in D.C., but they legalized the sale of marijuana in D.C. So unlike the other 4 states, Colorado, Washington, Oregon, and Alaska, where they've created a marketplace for marijuana, and the district didn't do that. So you can either cultivate your own, or you're going to have to buy it from your dealer still. To use it, you're going to have to buy it from an illegal source, mostly. Now, of course, one of the unintended consequences, of course, in Colorado, Washington, et cetera, is that by taxing marijuana to the extent that they do, they really, really tax marijuana if you're going to buy legally marijuana, they've created a burgeoning marketplace for illegal or black market marijuana in those states. Because you can get your marijuana cheaper from your old drug dealer than you can from a state-sponsored or registered dispensary because of the taxes that are involved. Now, see, they didn't create that legal marketplace, and it passed by the District of Columbia, has to be approved by Congress in the omnibus budget bill that was back in December, I think it was, if I'm getting my dates right. It mentioned there that struck down the marijuana law in the District of Columbia that was passed by the voters back in November of last year. So it's still somewhat up in the air. The pro-marijuana people are celebrating their victory in the District of Columbia, but there's still some ambiguity there as to the legal status of marijuana. But I just want you how this is progressing. So on the left of your screen are the 2013 recreational marijuana bills, not medicinal marijuana, but recreational marijuana bills. You can see there were 12 of them, and the ones in states that already had medical marijuana laws on the books. In 2014, the number increased to 20 states, plus the District of Columbia. Again, ones were states that already had medical marijuana, and we know it was passed in Alaska, it was passed in Oregon, and it was passed by the voters, at least, in Washington, D.C. So a good pro-marijuana people, right? 2014. This, not as many bills so far, but, and we're up to 15 with 3 more anticipated this year. But Ethan Nathan of the Drug Policy Alliance, who's been a pro-marijuana legalization guy for a long, long time, I was debating him on the radio probably close to 25 years ago when still with the U.S. Chamber of Commerce. He's projecting that California, Maine, and Nevada will very likely legalize marijuana for recreational use in 2015, and Massachusetts and Arizona are somewhat likely also. Now, it depends on your source. This is Ian Nadelman from the Drug Policy Alliance, but if you look on the Marijuana Policy Project website, if you look on the normal website, you'll find their predictions as well. They're all across the board, but there were 2 passed last year plus DC, and there's 3 or possibly 5 passed this year. You can see where the momentum is starting to build, and they're making progress toward, sweeping across the country. And a lot is by setting the groundwork, putting it in place by legalizing marijuana for medicinal purposes. That, again, never was the end game, but that's the thing that sort of softens the beach and makes it possible to get these recreational marijuana bills introduced in the state legislatures, and then either by referendum or by some other legislative means getting the law passed in those states. The states that have medical marijuana laws, Minnesota and New York passed their laws last year. 4, counting the District of Columbia, so 23 states plus D.C. have legalized medical marijuana. And there are a lot of bills, as I'm going to show you in a few slides, a lot of bills that have been introduced in a number of states. Some states have introduced more than one bill to legal marijuana for medicinal purposes. Here's the intent. With medical marijuana, it's always to decriminalize the use of marijuana by people who are suffering from, very serious illnesses. That's always the approach. It may be game, as I mentioned, but that's always the approach. That's the entry into the hearts of the public. Okay. Now, example, California, quote, removes state-level criminal penalties on the use, possession, cultivation of marijuana by patients who possess a written or oral recommendation. Remember, I said marijuana not be prescribed, right? Because it's a Schedule I controlled substance, and there, in definition, under Schedule I, there is no accepted medical use of the drug. That's still the federal law, even though it's been voted for medicinal purposes in 23 plus the District of Columbia. Under federal law, it's still a Schedule I drug. It still cannot be prescribed. And so you typically will not see the misuse of the word prescription or prescribed in the medical marijuana bills. In California, a little bit different. They take it one step further. You don't just need a written recommendation from a doctor. You could have an oral recommendation from a doctor. And there are countless horror of doctors who just take one look at somebody, ask them what their illness is, whatever it may be. They don't even check them for it. And then they'll fill out a written recommendation for that individual to be able to legally purchase marijuana at one of the hundreds of dispensaries that exist in the state of California. Okay? Sometimes the individual really have a debilitating illness, cancer, multiple sclerosis, Alzheimer's disease, etc. I can see that argument. I mean, I don't know if marijuana really helps people in situations, but I can see the compassionate side to that argument. The problem is in California and in most other states, there's a catchphrase, other chronic or persistent medical symptoms. That stress can be considered a medical symptom, and that stressed out on a daily basis, that could be chronic stress. Example. So Saturday, the trash guys come and pick up our trash. So Friday night, my wife's always reminding me to take the trash cans out. Well, I don't know what it is. It's just in DNA. Maybe I'm no different than any other husband. I'll sit down in front of the TV at 8 or 9 o'clock on a Friday night, all ready to relax and eat a bowl of ice cream, and will come in and say, don't forget to take the trash out. That was the last thing on my mind, and suddenly I'm very stressed out. Every Friday as if it was a chronic condition. Wouldn't it be better if I could go out into the garage, smoke a couple of joints, and really relax and put up in a really good mood, trash out, come back in, and be a happy guy? Wouldn't everybody be better off if I could smoke a couple of joints before I take the trash out on Friday night and make that chronic stress go away? Well, that's how absurd and ridiculous the arguments get at times. Now, joints every Friday night. I do get stressed out when I'm reminded, but I take the trash out. I don't smoke marijuana to relieve stress that's being reminded that I've got to take the trash out. But that is an absurd example of some really ridiculous, real things that happen. Minnesota passed a very unique medical marijuana law last year. Minnesota's medical marijuana law has really good protections for employers built into the law. Some cannot. Under the influence of medical cannabis that would constitute negligence or professional malpractice. This includes possessing or engaging in the use of medical cannabis in a public place, including a place of employment, navigating or being in physical control of any motor vehicle, well under influence of medical cannabis, etc., including a school bus or being on grounds. That Minnesota law goes. However, the Minnesota law prohibits, quote, discriminating against any person in hiring, termination, or any term or condition of employment or pay the person if discrimination is based upon the person being a registered medical marijuana user or, not and, but or a patient's positive drug test for cannabis components or metabolites, unless the patient used, possessed, or was impaired by medical cannabis on the premises of the place of employment or during the hours of employment. So a little bit of a Dr. Jekyll and Mr. Hyde there, right? But as mentioned, drug testing, it's in the context of restricting employers, but conditions may sort of force the employer to take some action. That took it a little bit further, even on Minnesota. This is all the result of case law that has ruled in favor of employers taking action against employees who test positive for marijuana. Now the marijuana legalization folks are closing these loopholes, and so now seeing this language. New York establishes protections for employees who use medical marijuana. Employers are prohibited from taking disciplinary action against employees simply because of their lawful use of marijuana. And lawfully using medical marijuana are considered to have a disability. Even though under the Americans with Disabilities Act at the federal level, marijuana users are not protected, are not considered to be disabled, they are under the New York Human Rights Law, the state's new medical marijuana law. And it may be required to make certain workplace accommodations for individuals who lawfully use medical marijuana. Have you been in an airport? Of course, there's smoking allowed in airports, except there's sometimes these glassed-in smoking rooms, right? I feel for the people in there because it's kind of like they're animals caged up in a zoo, and I don't mean that, in an insulting way, but they're sectioned off on their own, and they're in there smoking. Is it possible that in New York, employers to create designated marijuana smoking areas? The law does require us to consider making exceptions for medical marijuana users. It goes, may enforce policies and procedures prohibiting employees from performing job duties while impaired by a controlled substance. Employers are not required to allow employees to utilize or carry marijuana if it would violate federal law or put that company in jeopardy of losing federal contract. So, federal contract. And if you do, you can't allow employees to be under the influence of marijuana while at work. Yet, the New York law will allow that individual to be a legally registered marijuana user. But it does take into account that federal law may prohibit it. So, again, you've got the Dr. Jekyll and Mr. Hyde approach. Medical marijuana users have to have a registration card, identification card, and they've got to carry it with them. They may use that as a valid excuse if they test positive, but they've got to have that card with them. and New York, the marijuana law does not legalize smoking marijuana. You have some other substance. You can vapored marijuana. You can use oils, marijuana oils, or use it cooked in certain types of food, but you can't smoke marijuana. So somebody in the parking lot during their lunch break smoking a joint, they're not permitted under the New York or the Minnesota medical marijuana laws. If they smell of marijuana, they have that distinct marijuana odor, then that's a legitimate, reasonable suspicion that was the right to test that individual for marijuana as well as other drugs, and then the individual responsible if they test positive, because smoking marijuana is not legal under the medical marijuana laws in Minnesota and New York. Will that change someday? Absolutely. I'm sure that those loopholes will be closed because that's not what the marijuana legalization people want. These states currently or previously had marijuana bills active in 2015. You have a long list, and some of them died already. I put those in red. Some traditionally red states or conservative, typically conservative voting states. Go all the way to the bottom. The most red states, the most conservative state in the country, Utah, where I actually went to college, had a medical marijuana bill that fell one vote short in the in the state Senate of passage. That new battleground is because most of the states, the various voting states like California, Massachusetts, etc., have marijuana laws. They've already made it legal for medicinal purposes. They're all, progressing toward legalizing it for recreational use. So, well, the more conservative places, the southern states, Florida, Georgia, North Carolina, South Carolina, and places like Utah and Texas, which are typically very conservative states. Now, I'm kind of racing through to make sure we get through this next section before time, and we don't have time for questions. We will have time for questions, I promise you. But I wanted that we get to this point. This is how do you address marijuana in your drug testing policy, especially where it's legalized. Now, our business is writing drug testing policies. We need to put a dedicated marijuana section in every drug testing policy that we write, whether you state with a medical marijuana law or a recreational marijuana law, we put a section into your policy. You have to address the issue directly. You can't ignore it. You cannot assume that your policy covers it. You must address it in your policy in a very clear way in terms of the prohibited behavior or conduct section of your policy. You have to talk the fact that you drug test for marijuana, when and for what purposes, and you talk about the consequences for violating the marijuana provision in your policy. In other words, address marijuana very specifically and in detail. Clear. Let your employees know that being at work under the influence of marijuana or possessing marijuana while at work is a violation of the company policy. And what it means to be under the influence. Stay away from the terminology impair or impaired. Don't use that. Courts have long ago ruled that testing results don't prove impairment. Define what under the influence means in your policy. And one of those definitions is positive drug test result. In other words, employees prohibited from being under the influence, which includes smelling drugs, acting in a way that would indicate that the individual has been using drugs, or testing positive for any drugs that the company tests for. Action of any amount is considered a violation of the company policy. You typically use, and you may want to use it as well, related to the federal law. The federal still marijuana in Schedule 1, therefore it's illegal under federal law. And that's the reason, doesn't it? All pro-marijuana laws around the country are different. Every state is different. Both of them monitor the content of the marijuana. The content or potency of one of marijuana could be very different than another brand. cannabidiol content or level. FDA regulation, marijuana, for medicinal or recreational use. There is no regulation. There are safeguards in place. History of our country, well, I say that. Certainly in my lifetime, I won't tell you how old I am, but I'm old enough to know that a lot of drugs have been introduced in our country, but they're all FDA cleared. And a lot have been rejected by the FDA because they can't prove that they work or that they'll achieve the perform way that the manufacturer says that they'll perform. They may be legal in other countries, but the FDA rejects them in the United States. And yet we have a substance out there that's being touted as a drug that relieves suffering and help people suffering from debilitating illnesses. That's not in any way. There's no FDA oversight for marijuana. The policy can reflect that. It can reflect that type of language so they have a very legitimate basis for the position that you take as a company. I'm going to give you some basic policy language. Now, recognize that you take this and use it directly because every state law is different, and medical marijuana law is different. There are no two that are exactly alike. And there's case law in some states, in a growing number of states, that has on medical marijuana and its impact on the workplace. Individuals have been terminated from their employment for testing positive. Michigan and Colorado and Washington and other places. They're setting case law that you need to take into account as well as write your policy. So I would not recommend just simply taking what I'm about to show you, but use this as the basis for consideration. And then I would highly recommend you research the laws that apply to you. So the basis of the company recognizes that some state laws permit the use of marijuana either for medical or recreational purposes. However, the federal government continues to classify marijuana as a Schedule I controlled substance, thus make it illegal for use for purpose under federal law. That's the basis of your marijuana position. Then you're going to put in some prohibited conduct language. Employees are prohibited from being under the influence of marijuana at work or on company time as exhibited by a positive drug test result. Employees are prohibited from bringing marijuana or marijuana-related paraphernalia to work or using marijuana while at work, including breaks and other time off during an official work schedule. And then here's the consequences. Employees positive for marijuana, regardless of the reason for the use or the source from which the employee acquired the drug, will be considered violation of this policy and subject to possible adverse employment action as outlined in the consequences section of your policy. And hopefully every one of you has a policy with a consequences section, because otherwise your policy is like a tiger without teeth. You have consequences. It's got to be stated in the policy, and that's where you're going to get into the details of the consequences for testing positive for marijuana. Now, right to the end of my presentation, let me say this about oral fluid testing. For many years, people have tried to use the argument that the window of detection with oral fluid testing is short as with other testing methods. And I'm going to skip past here. The oral fluid mimics the window of detection with blood, which scientists will tell you is the gold standard of drug detection from the human body. Detection of drug use immediately in an oral fluid sample, just like with blood. That's why you see going to the far left being right there up against the black line, which is, the thing at which somebody used drugs. See that blood goes out for about a day or so. Oral fluid goes out a couple days, depending on the drug and the cutoff levels. Urine does not open up. The window of detection does not open up immediately. It's an hour or two lag time. So if you smoked a joint at lunch, you test them right there on the spot. They're not going to test positive for that marijuana. They maybe for the marijuana they used with their breakfast in the morning, not for that drug use, okay? But the window of detection is going to go farther out, a period of days, usually 3 or 4 days. Testing, you've got about a 7 to 10 day lag time from the point of the ingestion of the drug, but you've got a 90-day window of detection. Well, states where marijuana has been legalized and you don't have any right to know what I was doing over the weekend, those circumstances, immediate detectability factor with oral fluid testing comes into play as a huge advantage. The wind detection is historically shorter or smaller with oral fluid compared to urine, but the ability right after use, almost immediately after the use, makes oral fluid testing perhaps a method of choice in like Colorado, Washington, and other places, right, we're concerned about taking a look back into that individual's usage history or into their life cycle. I predict oral fluid testing, which has a number of advantages, I think, that are attractive, and it's a growing area of drug testing. I'm in favor of all types of drug testing if done right. I just did a presentation last week on hair testing. But I think it's going to grow in popularity, in part because the federal government's in the process of developing regulations that will make lab-based oral fluid testing legal under the SAMHSA regulations and vis-a-vis at some point under the DOT regulations. But in these states where marijuana has become legal, where the employer is maybe a little bit skittish about looking too far back into somebody's lifestyle, with oral testing, you're going to get that tight window of detection, and it's going to be very, very difficult for somebody to whip out of the positive drug test result by arguing that they used drugs 3 or 4 days ago. Now, the activity rate with lab fluid testing, which is that middle column under the word intercept, which is the OraSure device, and traditional or classic urinalysis testing, the rates are very, very similar. As you can see, 4.1 for % positives under the intercept device, the lab-based oral fluid testing, 4.4 for urinalysis. But take down the 4 listed THC, active ingredient in marijuana, 2% positive rate under lab-based testing with oral fluid, 2.3% for based urine testing. So in that very critical area that we're all concerned about, marijuana, the positivity rate with lab-based oral fluid testing actually a little bit higher. Okay, I want to leave time for Jen to bring up some questions. So before I forget, thanks to OraSure Technologies for hosting today's presentation, and to EBI. The two of them together are a powerful team bringing good, positive, timely, accurate information to the industry and to the employer community. And with that, I'll turn the microphone over to Jennifer.
Great, Bill. Thank you so much. Wonderful presentation. I do have some very interesting questions for you. First, Ernie asks, are there restrictions for asking pre-employment questions around medical use of marijuana, or would that be a HIPAA violation?
Well, not a HIPAA violation. Here's where the sort of the trend is heading. Under EA, of course, we know that medical exams of this nature are prohibited. So you got part of the screening process. An alcohol test is considered a medical exam under the ADA. A drug test is not. So you see all kinds of restrictions on alcohol testing of job applicants, but none when it comes to drug testing. But the case recently ruled in which the court found that if that employer or an employer conduct test after a conditional offer of employment has been conducted, in other words, just sort of test everybody who comes in to apply for that job, and not post conditional offer of employment, the testing could be considered a medical inquiry or a medical exam. And so what we advise employers to do from a policy perspective is you can still test for marijuana on a pre-employment test, even in in Colorado and Washington, Oregon, but do it after you've made a conditional offer of employment to that job applicant. Then you're still on safe ground.
Okay, people had very similar questions based on comparing this to alcohol. And you have your BAC, and you can find out if somebody's impaired or not right now. Is there any way an employer can ever figure out or even define what impairment is?
Well, standpoint, the courts have ruled long ago that a drug test result does not prove impairment, right? And so, one person's affected by one joint one way and another person's affected by one joint another way. The THC content may be different from drug to drug, et cetera. So what we do know, though, is that in Colorado and Washington, two states that have legalized marijuana for recreational purposes, they pass laws for roadside drug driving that considers a positive drug test marijuana at 5 nanograms per milliliter milliliter to be a positive test that indicates the individual is either under the influence or impaired, depending on the use of the word by the state. So the situation is fluid. We don't know where that's going to land, but at least in those two states, we have some indication that the 5 nanogram cutoff level per milliliter is perhaps where we're going to end up in terms of kind of trying to compare it to the alcohol content of 0.04 or 0.08 at the the federal level. So definitively right now, we do a little bit of guidance or revelation from Colorado and Washington. Will we end up there? I don't know in the long term, but right now that's the best that we've got is that 5 nanogram per milliliter cutoff level for drug driving.
Well, I've got another question that kind of might touch on things for people in border states, and I think your answer might be very important to folks. The question is, we're based in New York State. We have a federal contract for reimbursement of Medicare funds. Do we follow the state law or do we follow the federal law?
Well, New York's a great example of that, and it brings up two really important questions. So first, directly to your question. If you contract, you are required to comply with federal laws. Now, laws trump state laws. That's always the case. Now, decided that they're going to enforce marijuana laws, the federal marijuana laws, in states that have legalized marijuana at the state level. Attorney General Eric Holder has basically said, to Colorado, Washington, when they pass their laws, we're going to wait and see. We reserve the right to come in and file lawsuits, but right now we're going to see how this goes. So in other words, he sort of by de facto said the federal government's not going to do anything about this. But in federal contract, you are required to federal law, and right now marijuana is still considered illegal under federal law. Will the government enforce that with your federal contract in the state of New York? I can't predict that. But if we're just going by the basic facts, you have to comply with the federal law. The other thing that comes out of this, kind of to what you said, is what if you're in a neighboring a legalized marijuana state like New York? So maybe you're in New Jersey where they do have medical marijuana, but they don't have recreational marijuana. Or we're in Idaho where they don't have either, but they're sort of locked in by Washington, Oregon, and Colorado in terms of states that have legalized marijuana for recreational purposes. Individuals from your state, you residents, can go to Colorado and legally purchase marijuana there, but bring it over the border into your state, it's legal to possess it and it's illegal to use it. Something in mind from an employment standpoint.
We're getting near the end of our time, but I'd really like to squeeze in one more quick question, and it has to do with reasonable suspicion. Can you, if you live in Oregon, for example, can you send an employee out for drug testing if you smell marijuana on them?
Okay. Well, I wouldn't definitively answer that question, but I'm going to take a shot at it because this is also new, especially in Oregon and Alaska, which they just passed their laws a handful of months ago. Make policy clearly states that individuals may not be at work under the influence of marijuana. They cannot be acting in a way that would give reasonable cause to believe that they're under the influence of marijuana. And if the company suspects that an individual is at work under the influence of marijuana, this is what will happen. This will consistently be the way that we address this issue in our company. If you can come back and show that you address marijuana in your policy, your policy reflects the state law that applies to you, and how you're going to address it on a consistent basis. All right, so it can't be arbitrary from one supervisor to another as to how they do this. It's got to be consistent. But if your policy reflects the fact that you're addressing marijuana specifically as it relates to the law that applies to your state, and then you put which in there that clearly states employees may not be at work under the influence, may not act in a way that would raise suspicion that they're under the influence, then you're on safe ground for now. We don't know what's going to happen going forward, but right now employers still maintain the right, responsibility, as Jennifer said in her introduction, to ensure their employees, their customers, their clients, and the general public that they're doing everything within their power to make sure their workplace is safe, whether it deals with drugs or whether it deals with the functionality of the car cars that the company has their employees drive. You're doing everything to make sure that your company is as safe as possible, and I tell you, address it from a marijuana standpoint, at least for now.
Okay. Well, one final thing quickly. We got a really interesting question. What's the common disciplinary action for a positive result? Have you heard? Are people doing dismissals, second chance agreements? What do you hear out there?
We know from last year's industry survey that we did here at the Current Consulting Group that 17% of drug testing providers say they've had clients discontinue testing for marijuana. So we're seeing a little bit of a panic reaction on the one end. On the other end, I think a lot of employers are really sort of holding ground. And I think if you're a drug testing provider, you give that advice to your clients that they've got to be firm on this issue, because what happens, and this is really what it comes down to, what happens if you have an employee in the state of Oregon who, under the influence of marijuana, and is driving a company-registered truck and causes, heaven forbid, a fatal accident, responsible for that. The employer will be held responsible for that. So you still have a responsibility to address that issue, regardless of why the person says they're using the drug or what the circumstances may be. Employers still have a right and responsibility to take action on this issue.
We are up against the clock, so I'm going to have to say thank you to you. And on behalf of EBI and OraSure Technologies, I'd really like to thank everyone for joining us today. We hope you have found this presentation informative and helpful. The whole event was recorded, and you will receive instructions soon on how to access that recording. Today's presentation is approved for 1 credit hour of continuing education from SITAC for CPAs. So if you're interested in receiving that credit, please email request to info@currentconsultinggroup.com. Thank you for attending today, and this concludes today's webinar.